to the Roundup, covering what's important to accountants and advisors across the month of March. Inside this month, we look at the tax implications of how travellers manage for employees. This is an update to the Bechtel case. But first up, we're looking at how the ATO is wielding Part 4A against professional practices. Now, Michael, professional practices have been in the ATO spotlight for many years now, but we've seen an uptick in activity before the tribunal, looking closely at how some professional practices are distributing their profits. What can you tell me?
Yeah, so many practitioners would be aware that for a little while now, the ATO has certainly been putting more focus on the way that professional practices distribute out their profits and where those profits are ultimately being taxed. And so we've seen some guidelines, a couple of different versions of some ATO guidelines, which effectively are being used by the ATO to basically determine the level of risk that a professional practitioner might be subject to from a Part 4A point of view. Basically saying that, look, if you're involved in generating income of a professional practice, there's some expectation from the ATO that you will be personally taxed on an appropriate share of the profits that are being generated. And if you fail to do that, then there's a risk that Part 4A could apply. Now, I guess the response to that from some people has been, well, this is really just the ATO making up these guidelines. What are these actually backed by? The ATO has been looking for a test case to basically get the courts to turn their mind to this issue. But so far we haven't really seen that, not in any detailed way. But we're starting to see something at least on those lines. And we've had two AAT cases over the last month. They're linked, the Grant case and the Colley case, basically kind of similar parallel cases where the issue of Part 4A came up in connection with the way that profits from a legal firm were being distributed out. So in this case, two solicitors, they were involved in this legal practice. Basically what was happening is that some of the profits of that practice were being distributed in a fairly convoluted way through a series of trusts and ending up in the hands of companies that certainly had some tax losses in them and also some tax-exempt entities. So from a tax point of view, little tax being paid on these profits being distributed out. However, the funds that related to these profits were effectively finding their way into the hands of the solicitors and their related parties in the form of a loan. So you had this difference between how the income was being distributed or appointed on paper and what was happening with the cash itself. And this was an area that got picked up by the ATO, and the ATO decided that Part 4A was the appropriate tool, I guess, in the ATO's arsenal to basically attack what was going on. Now, the short story is the AAT agreed with the ATO on this one and decided that Part 4A did apply in this scenario. Now, there are a few reasons why the AAT decided that this was something that fell within the scope of Part 4A. There was clearly a tax benefit when you compared what had actually happened with, I guess, an alternative that could have happened. And the AAT was comfortable that this series of transactions, or at least on paper, was basically done with the dominant purpose of obtaining a tax benefit. So AAT found that Part 4A did apply. The result being that the solicitors effectively were being taxed on an amount that on paper was being distributed out to these loss companies and tax-exempt entities. Now, the solicitors were arguing that, well, look, when we're trying to come up with what would have happened, so if this hadn't happened, what would have happened? They said, well, we were high-risk individuals. We're subject to a high level of risk. From an asset protection point of view, we wouldn't have distributed that income to ourselves anyway. The AAT said that's not enough. It's not enough to show what you probably wouldn't have done. You've got to show what would have happened. And the AAT said it would be reasonable to expect that if you're a solicitor and you're involved in generating the profits of a law practice, that you would be taxed on some or all of those profits that relate to the work that you've performed. And so the argument put forward by the solicitors didn't convince the AAT in this case. So I guess we could say that this is one step in, I guess, the ATO's approach over recent years, possibly gaining a little bit more traction. On the other hand, you might say, well, this is a bit of an extreme example. I mean, this is a fairly artificial and convoluted set of facts where we've got distributions through a series of entities ending up with some tax-advantaged entities. does that really mean that Part 4A is going to apply if me as a professional practitioner simply distribute some profits to, say, a related party, say a spouse or some adult children, etc.? The case doesn't really tell us that for sure, but it does suggest that the ATO might be at least somewhere on the right track in suggesting that professional profits distributed out in a tax advantageous way in a slightly artificial manner could fall within the scope of Part 4A. Now, the other thing to remember, of course, is that Part 4A isn't the only weapon, the only tool that is available to the ATO. Certainly Part 4A is there. Remember, we also have to consider the PSI rules. They won't be applicable in all cases, but there certainly will be scenarios where you're really dealing with the PSI tests and the implications of, say, attributed income. We've seen recently that Section 100A is also something that could potentially apply in situations, particularly where trust distributions are involved. So we'll see what happens with this case. We'll see whether it is appealed, and if so, what ends up happening. But it is worth just pointing out here that we've got ATO guidelines. We've now got something that kind of sits alongside those guidelines in terms of a tribunal decision as well.
It seems like these aren't the only Part 4A cases this month. Has the ATO had further success?
Yeah, so it's interesting. We go kind of a long period of time without seeing a whole lot of movement, I guess, from a Part 4A point of view. But just this last month, we've had 3 or 4 cases where Part 4A has been the real focus. So it's interesting to see that, and it does make us wonder whether the ATO is being a little bit more active in general when it comes to Part 4A, not just in the context of, say, professional firms. The other cases that really focused on Part 4A, the Minerva case and the Mylan case, were both quite different. Pretty complicated set of facts, and we're not going to go into those set of facts kind of in this forum. But the interesting thing to note in both of those cases is that the ATO was not successful. So in each case, the court found that, yes, there might have been a tax benefit that was obtained from the arrangement, but that tax benefit was not the sole or dominant purpose of entering into the scheme or the arrangement. And I guess what these cases demonstrate is that Part 4A is a very, very complex area. I think a lot of us who've kind of looked at Part 4A at any point in time would realise that. I mean, it's certainly not a simple provision to apply. But these cases demonstrate, I guess, the importance of a few things. First of all, really understanding the facts. The facts really do matter. We know that any time a matter goes before the tribunal or the courts, so much time and effort is put into establishing the facts, because the facts really tell the story, and they are the basis on which, the decision is ultimately going to be made. One of the things, again, that is relevant in these cases is the fact that the arrangements weren't, I guess, artificial or convoluted or contrived. There were certainly a series of steps that were undertaken, but the court in each case found that those steps were fairly normal in the context of the arrangements or the transactions that were occurring. That is, the things that were being done were the sorts of things that you would typically expect to be done in those types of scenarios. So we had an absence, I guess, of, say, those artificial or contrived steps or features that we saw, I guess, in the case dealing with the professional practices, the solicitors. The other thing to note from particularly one of these cases is it involves some intragroup financing. And it was clear that the parties were structuring that financing partly in a way to avoid the loss of deductions for interest expenses under the thin capitalisation rules. Now, those are a pretty complex set of integrity rules that deal with debt, equity financing and interest deductions. And the court basically said that the fact that they have basically deliberately structured the affairs of these entities to stay within, I guess, the safe harbour provisions of the thin cap rules doesn't mean that obtaining a tax benefit was the sole or dominant purpose of the arrangement. And I guess it kind of makes sense that if there's an integrity rule that is kind of designed to kind of keep you within a certain limit in terms of your debt funding, that you would pay attention to that as you go about structuring your affairs. Again, complex cases with complex sets of facts, complex decisions as well. Look, if you're kind of struggling to get to sleep at night, go and have a read of these decisions. They do point out that Part 4A is difficult. It is possibly a suggestion that the ATO is turning to Part 4A a little bit quicker or more readily than maybe what the ATO has in the past. And some of you who really kind of study this area might know that there were some amendments made to Part 4A a little while back. On the surface, they might have seemed like pretty minor amendments, but they do increase the power of Part 4A, make it that little bit easier for the ATO to win a Part 4A case when it comes to the courts. These decisions mean that it's certainly no guarantee that the ATO is going to win. The fact that the ATO raises Part 4A or attacks something under Part 4A, there's no guarantee that the ATO is right. It is really about getting stuck into that analysis. Complex analysis is required, but we need to keep in mind the fact that we're seeing Part 4A a little bit more often. So keep that in the back of your mind as you're working through client scenarios. By all means, we're looking at all the different integrity rules that sit within the tax system. Don't forget that general anti-avoidance provision that kind of sits above everything else. We always just need to keep that in mind as we're structuring things, working through scenarios with our clients.
If we turn to the ATO now, Matthew, is there a reason why ATO activity has become more concentrated on professional practices right now?
Yes, that shouldn't come as a surprise. Now, with the ATO having finalised its guidelines on the allocation of firm profits or professional firm profits some 2 years ago, it was all just going to be a matter of time before the ATO would move towards engaging practitioners, or I guess towards the more pointy-ended compliance. And that's what's happened here. So late last year, the ATO started contacting practitioners on how their arrangements were viewed under these relatively new finalised guidelines. And it's just worth revisiting what these guidelines are trying to target. So they're not focused on firms that generate income from personal services, so your one sole practitioner firms with no employees. And that's because the rules are far more stricter for situations like that. Rather, these guidelines are targeted towards firms that generate income from a business structure. So firms with potentially multiple partners, firms with multiple employees, or firms with some business goodwill. And similar to one of the Part 4A cases that was discussed in the roundup also this month, what the ATO are concerned about is where there's a disproportionate amount of professional firm profits that are being diverted away from the principal practitioner towards the practitioner's related parties. So that might be a spouse or a bucket company, but where they're ultimately on a lower tax rate. And the ATO is a bit concerned where this is all being done with the purpose of avoiding tax. Now, the ATO is saying that, look, there's some reasonable limits in terms of how far you can go with this before we start moving into anti-avoidance territory. And that's what these guidelines are here for. Once some gateway tests are passed, these guidelines provide practitioners with 3 benchmarks that they can self-assess themselves on, which gets them to a score. That score determines whether they're seen as low, medium, or high risk. And it's that risk rating that determines the level of ATO attention and I guess the level of ATO compliance resources that they'll dedicate to reviewing the arrangement. The issue now is that with the ATO having commenced sort of risk assessments and started looking to this area, they're starting to uncover some other problems as well.
So as the ATO have been looking into and delving into professional practice structures, what else has the ATO been discovering as they've been doing that?
Sure. Before I get into that, I just want to put some numbers to all this. Now, the ATO is saying that just in the 2023 income year, they've raised about $30 million of tax liabilities just from looking at practitioners. When the ATO are doing these risk assessments on the allocation of professional firm profits, what they're fundamentally looking at are profit distributions. And they're finding simply there are instances where practitioners are not disclosing these profit distributions in their own returns or disclosing these profit distributions only in part. The ATO are also saying that practitioners aren't as good or aren't as strong in terms of lodging their own returns. So specifically, they're saying that practitioner lodgment compliance is lower than what they would expect. And the ATO has been quite active in that front in terms of engaging practitioners to make sure their returns are up to date. And it's important to keep in mind that this can have broader ramifications, with the ATO quite keen to remind us that not maintaining compliance with your own personal tax affairs can impact your tax agent registration. And we've seen that happen in a number of cases. So what I'm trying to say is that not only is it a good idea, not only is it prudent to check to see how you stack up, in terms of the professional profit guidelines, but it's also important to make sure that you're attending to the fundamental things, making sure that you're disclosing distributions that are consistent with what's actually been distributed, making sure that you're lodging returns on time, making sure that you're paying tax liabilities on time as well, or entering into a payment arrangement.
Travel is always one of those areas of compliance that's fraught with danger and detail. Matthew, there's a full federal court decision this month that revisits some of the key principles on travel deductions. This is for fly-in and fly-out workers. What can you tell me about the case?
Yes, the Bechtel case, a full federal court decision. It's an FBT case, but it has some wider ramifications for employees looking to claim travel deductions. Now, the employer in Bechtel, they had some fly-in, fly-out employees that worked on Curtis Island, and those employees worked 4 weeks on Curtis Island and then had 1 week off. And what the employer did was they arranged and paid for the travel to get the employee from their home airport to Curtis Island. Now, there are some FBT exemptions that can apply when travelling to a remote location for work, but they didn't technically apply here. So the full federal court had to look at the otherwise deductible rule. And the question there is, had the employee incurred the expense, would they be entitled to claim a deduction for the flights, for the transport personally? And if it's deductible to the employee, then it's otherwise deductible for the employer, and the employer shouldn't have an FBT liability. The starting point, though, when it comes to travel deductions for employees, is that it's not normally possible for an employee to claim deductions to get between their home and their regular place of work. And that's fundamentally for two reasons. The first is that it's seen to be private in nature, or it's seen to be travel undertaken to get the employee in a position to earn income, so it's incurred too soon. One of the exceptions to this, though, was established in the John Holland case, some 9 years ago almost, and it's a full federal court decision also dealing with fly-in, fly-out workers. And what the court said in John Holland was that for fly-in, fly-out workers, it can be possible in some cases for these workers to commence claiming travel deductions from a departure point. And that might be a departure airport before and in the course of getting to their substantive place of work. Now, that's only possible where two main conditions are met. The first is that the employee is rostered on, they're paid from that departure point onwards, and also that the employee is subject to the direction and control of the employer from that point onwards. There were some similarities between John Holland and Bechtel in the sense that the employees in Bechtel, it seemed like there was some indication that they might actually be under control or under the firm's policies, firm's conduct policies while they were travelling. However, the key difference though is that in Bechtel, those fly-in, fly-out employees, they weren't actually rostered on. They didn't actually start the shift until they got to Curtis Island. And what that meant was that fundamentally, they were seen to be travelling in order to get to work, in order to start work, rather than travelling while working. And that made the difference in the Bechtel case. And the travel deductions, the flights, they weren't deductible to the employee and therefore not otherwise deductible to the employer. And this Bechtel case, I think it's a timely reminder, given that John Holland was almost a decade ago, that just because someone's a fly-in, fly-out worker, that alone isn't really sufficient, right, to claim deductions for travel to get to a normal place of work. Being a fly-in, fly-out worker, that's not sufficient by itself, and there really does need to be more than this, and there are certainly other factors that do need to be looked at.
And that's the roundup for this month. If your firm is not a member of Knowledge Shoppers yet, whether you're an accountant or a financial advisor, we'd love to show you how we help thousands of professionals across the country every single day. Give the team a call or jump onto the website and book in a time that we can show you what a difference we can make. Talk to you soon.